You're sitting behind the wheel of a car you bought 3 days ago, and it won't start. The dashboard looks like a Christmas tree, the engine is making a sound like shaking a can of marbles, and you're stuck in a parking lot wondering how you just spent $4,000 on the giant paperweight. You're probably asking yourself if you've any legal rights, or if you just got taken to the cleaners. Keep watching, because the clock is ticking, and the first mistake people make in this exact situation costs them any chance of getting their money back. We're going to walk through the massive errors that lock you into a broken car, why those mistakes ruin your leverage, and exactly what you need to do instead to protect your wallet. The absolute first mistake people make is ignoring the paperwork in the glove box. When you buy a used car from a dealer, you usually get a massive stack of documents. Buried in that stack is almost always an arbitration clause. An arbitration clause is a piece of paper that says you give up your right to sue the dealership in a regular public court if something goes wrong, and instead, you have to hire a private judge to hear the case. People get intimidated by the word arbitration and they just give up. They assume they can't fight a big dealership in a private legal system, so they just accept the broken car and start paying for repairs out of their own pocket. That's a massive mistake that costs you thousands of dollars. What you do instead is read that arbitration clause very carefully. Because here's the secret the dealers don't want you to know, that arbitration clause is a two-way street. In many states, if the dealership forces you into arbitration, they have to pay the majority of the filing fees just to get the case started. The exact rules change depending on where you live, so you have to check your local laws. But suddenly, when you file a claim against them, the dealership realizes they have to write a massive check just to defend selling you a junk car. A lot of times, simply filing for arbitration forces the dealer to buy the broken car back from you because it's cheaper than paying the private judge. The next huge mistake is talking too much and texting too little. When the car breaks down, you call the dealership, screaming and demanding a refund. The dealer tells you to bring it in, they look at it, and suddenly they claim you installed an aftermarket part that ruined the engine. You're standing there with no proof, it's your word against theirs, and you look like the bad guy. People think a verbal agreement over the phone is going to save them. It won't. Memories fade, and salesmen will absolutely lie to protect their commission. What you do instead is put absolutely everything in writing. Every single text message is a permanent, time-stamped record. Take photos of the dashboard warning lights. Get everything in a text message. When you send that text, you're building a paper trail. If you call them, immediately follow up with a text that says, "I am following up on our phone call regarding the engine failure." This prevents them from twisting your words later. A massive mistake is falling for the free repair trap. The dealer says they feel bad, so they'll fix it for free in their shop. You think you won. But here's what actually happens. They keep the car for 3 weeks, they charge the dealer nothing, and they hand you back a car that breaks down again a week later. The reason is simple. The mechanic who sold you the broken car isn't going to suddenly do a perfect rebuild on it for free out of the goodness of his heart. Accepting a verbal promise for a free repair is deadly. If you agree to a repair, you must get a separate document, often called a repair order. A repair order is a formal work ticket from the shop that details exactly what parts they're replacing, what labor they're doing, and how long it takes. You also need to understand the concept of a warranty. A warranty is a legally binding promise from the seller to fix specific defects for a specific amount of time. What you do instead is negotiate a formal, written warranty before they ever touch the car. Get it in writing on the repair order. If they refuse to put their free repair promise in writing, don't leave the car with them. A verbal promise doesn't mean a thing when the engine catches fire a month later. Another critical error is misunderstanding the word sold as is. When you see that phrase on the buyer's guide, your heart sinks. You think it means the dealer has zero responsibility no matter what happens. A lot of buyers just walk away at this point, thinking the law is completely against them. Selling a car as is means the dealer isn't providing a guarantee, but it doesn't give them a magic shield to commit fraud. Fraud is when someone intentionally lies to you about a material fact to get you to buy something. If the dealer told you the car had a brand new engine and you open the hood to find a rusted block from 20 years ago, that's fraud. Fraud destroys the as-is protection. What you do instead is look for the lie. Pull your phone records. Did the dealer text you that the car was in perfect mechanical shape? Did they write flawless transmission on your copy of the purchase agreement? That written lie completely overrides the as-is box. Don't walk away just because you see those 2 words. The final huge mistake is letting them sell you a service contract as a solution. A service contract is a paid policy you buy that covers specific parts that break down, which is totally different from a warranty. The dealer messes up, the car dies, and to keep you happy, they throw a service contract at you. People take the service contract thinking they're safe. But here's the trap. These contracts have massive exclusions. They might cover the water pump, but they exclude the seals and gaskets around it. So when the pump fails, the contract pays for the cheap pump but leaves you holding the bag for thousands of dollars in labor to replace the destroyed seals. The contract also requires you to use a specific mechanic, and that mechanic will absolutely find a way to deny your claim. What you do instead is remember that a broken service contract doesn't fix a broken engine. If they sold you a car with a defect that existed the moment you drove it off the lot, your argument is that the car was defective at the time of sale. Don't let them distract you with a useless service contract that shifts the burden of their bad engine onto a third party. So when exactly do you call a lawyer? That's the ultimate question. You call a lawyer when the repair cost is higher than the value of the car, or when the dealer flat out refuses to honor a written warranty. This happens more than you think. Lawyers who handle car fraud usually work on something called a contingency fee. That means you don't pay them by the hour. They take a percentage of the money they win for you. Don't try to fight a dealership in arbitration or court by yourself, because they have attorneys who do this every single day. I want you to think about the last time you had to deal with a mechanic who tried to pull a fast one on you. What was the most ridiculous excuse they gave you for a car problem? Let me know down in the comments. If this breakdown gave you some ammunition for your next trip to the auto shop, send this video to a coworker who's currently driving a car they don't trust. And make sure you subscribe to Scribble Law so you always know the playbook before someone tries to pop the hood and rip you off.